going to focus this really on sort of the ethics that work around 1031 exchanges. And, as when I was a little kid and, did a book report or wrote about something, it's always nice to start with a little bit of definition of what we're talking about here. And so by way of Black's Law Dictionary, which I have somewhere up there, and I don't know, maybe you guys still have yours from law school. But as it relates to ethics, we're talking about moral action. We're talking about, conforming to professional standards or conduct. And of course, the New York Rules of Professional Conduct, about 286 pages. I know you all read it in anticipation of this presentation. It was amended in June of 2022, and there were some comments amended in January of 2025. So there were a couple of things. I took a look at what that was. It's really around Rule 1.10a about personal interest and conflicts. We're going to talk about conflicts of interest, but what that amendment is really not the comment that was amended. It doesn't really have to do with what I'm going to talk about. I'm not talking about all things within this ethics, of course, and probably would be remiss if I didn't say, please don't take any of this as legal or tax advice. But, these are some of my thoughts around where, when you are advising clients around 1031s, you need to, sort of have that moral compass pointing the right direction. Malpractice, of course, is a function of unreasonable lack or skill. And, that's not a place you want to be. The preamble in paragraph 12 talks about, with regard to lawyers' responsibilities, that the violation of these rules that we'll talk about in here don't necessarily in and of itself give rise to a cause of action against a lawyer, nor does it create a presumption that a legal duty has been breached. But nevertheless, because that rule does establish standards of conduct for lawyers, the violation of a rule may be evidence of a breach of that applicable standard of care or conduct. So, just something to keep in mind as we are talking around this. So, of course, as it relates to lawyer functions, being an advisor and, an advocate, a negotiator, an evaluator, these are sort of the lawyer functions that you take on. I'm just trying to move my... And by the way, it was mentioned earlier, if there's a question, feel free to put it in the chat or Q&A. I'll try to tackle it unless it's going to kind of derail. I got a lot of material to go through, so I want to kind of try to be swift through this. But, we can certainly take it offline. And, I think as Richard sort of touched on, so I'm an attorney. I hold a certified exchange specialist designation. I do not give legal or tax advice. My role as a qualified intermediary is to structure the exchange, and equally as important to hold the money. And we'll talk about that in the G6 restrictions a little bit later on. So again, I am not negotiating any contracts, handling any closings. I'm performing that function that you all, a client's accountant, a client's realtor, is not permitted to perform. So this is my screen. Let me move that out of the way. Hopefully that's a little better. No, that's not helping. Just having a problem with the size of this in my video. So can't get this to go away. Okay, that might be better. All right, so we're going to talk about some of the preamble here. And, in all the functions that we talked about on the prior slide, got to be competent, right? You got to be prompt and diligent. And we're going to touch on some of the 1031 rules just very, very briefly. But there are critical deadlines involved here. And so depending on how you are engaged to work with a client, you may be involved in facilitating identification and adhering to those deadlines. Or, we'll talk about the scope of engagement. You may just be negotiating a contract and handling the closing. So we'll talk a little bit about that. But in all cases, of course, communication, which will be discussed as another point a little bit later, is a given, right? Very important. And some of these ethical problems arise from a conflict between a lawyer's responsibility to their clients and the legal system, and sometimes their own interest. So the rules hopefully are, creating some resolution around these conflicts. Now, as we talked about, the failure to comply with these might be a basis for disciplinary processes. The violation, again, doesn't necessarily give rise to a cause of action, but because these rules do establish some standards, that is something that you've got to balance, that you don't want to be in breach of. When it comes to sort of plaintiff's counsel, so should there something go awry here, what they are going to be looking for are, first and foremost, clear mistakes. So, it would be pretty important to be competent around 1031 exchanges if you're going to hold yourself out as an advisor working with 1031 exchange clients. Conflicts of interest, another area that counsel is going to look to. And lastly, a high economic loss. And of course, with 1031 exchanges, we are talking about the deferral of federal capital gains tax, depreciation recapture tax, state income tax, and net investment income tax. So, let's call it 35% of the gain in a sale of investment property. So, it can be a high number. I've been involved in an exchange over $1 billion. Rest assured, had something gone awry there was a big tax issue, and you don't want that to be falling on you for not adhering through the process correctly. Attorneys often get into trouble, of course, with their client selection and retainer agreements. And so we're going to, again, talk about that in the scope of representation. So let's start right here with competence, right? First and foremost, if you're going to be engaged and hold yourself out as a professional and a 1031 advisor, then it would be reasonable that a client is going to expect competent representation. Now, that can be acquired through, preparation, classes, things like this. And of course, experience is something that is, hard to substitute. Certainly should not handle a matter that or you're not competent to handle. You can always bring in counsel, whether it's tax counsel if necessary, or we'll talk about if there are conflicts where you may want to bring in counsel to represent one of the other parties. That is definitely something that you're going to want to consider. Again, the expertise in the field would be expected. Again, you can take classes. You can, by virtue of that experience, you will be better suited to issue spot. It's very important to understand, for example, partnership issues. And if you're dealing with a partnership and those partners want to go their separate ways, well, there may be strategies to do what we call drop-in swaps or swap and drops or partnership divisions, all sorts of ways that you may be able to assist and get ahead of potential issues, but only if you can spot those issues. Related party transactions, knowing that your client wants to buy a property from their family member through their exchange, to immediately spot, that's really going to be a challenge. So these are things that you want to think about. Now, with regard to what's at stake here, if a taxpayer does not have sort of a reasonable basis for doing what they do, so if there is, for example, you are advising a client and there's no reasonable basis for their exchange procedure there, typically at a top rate, well, I shouldn't say top rate, but there's a 20% penalty for negligence or disregard of rules or regulations, or for a substantial underpayment. Okay, now you can mitigate that if there is substantial authority for your position, and if that position is disclosed and there's a reasonable basis for it. So I'm going to kind of say this now, and I will probably say it quite a number of times throughout here, but a CPA is your lifeline with an exchange. You are not doing your client's tax returns. you're not going to be privy to whether they have carry forward losses that might negate the reason to do an exchange, or whether they just inherited the property and maybe they got a stepped up tax basis and don't have a gain. I'll talk a little bit more about this in a little bit, kind of when you're engaged. But, these are things that you kind of want to start to think through. Oftentimes I'll hear people say, well, what are the chances I'm going to get audited? Now, there certainly appear to be certain transactions that will likely get audited more than others. Related party transactions, for example, which has a check the box on their 8824 that it is part of a related party transaction. And, it would seem reasonable that what the IRS is concerned with a related party transaction is basis shifting. And so it would appear that that might be something they're going to take a closer look at. But just to understand that the possibility that a return is going to be audited is not relevant in determining whether that substantial authority standard is the reasonable basis would be satisfied. And, pursuant to the Circular 230, that a practitioner must not, in evaluating a federal tax matter, take into the account the possibility that it may be or will not be audited. Okay, so that's just something to keep in mind. Probably don't want to be out there kind of saying to, oh, well, you can play the audit lottery, or I don't really see much of an audit risk. It's not really how you should be positioning things. So just very quickly, we're talking about 1031 exchanges. This sort of presupposes that you've attended, hopefully, my prior judicial title 1031 exchange class, but you have some familiarity around this. And of course, 1031s have been around since 1921, albeit a different tax section. But it's a methodology for real estate investors to defer their capital gains tax, their depreciation recapture, their state, and their net investment income tax. These kind of highlight the four statutory requirements: that there is an exchange, that there is real property, that real property has been held for productive use in a trade or business or for investment, and then again, that it is being exchanged for other like-kind property. So again, those are the four tenets, not getting into that in this presentation, but again, there are critical deadlines that begin upon the sale of that relinquished property to the new buyer, and that is 45 calendar days to identify, 180 calendar days to close on the replacement property. Again, are you going to be involved in assisting with monitoring those dates, in assisting with the identification? That comes back to the scope of representation. Rules around debt and equity, recognizing that your client has to reinvest all their equity and replace all their debt to fully defer their gain. So if you are aware that they're only buying one property and they are over leveraging that acquisition and not getting their equity into it, that's going to be a problem. That may be by design, and that's okay if they just want to take out some cash and pay tax on it, but understand the ramifications of how they are moving forward. And the same taxpayer requirement. Again, there are partnership issues, which is outside the scope. I touched on it in the prior, and I do a whole advanced class around that. But understanding that if Diana and I, for example, own a building together in a partnership, that we don't get to just take our share and do our own exchange without some advanced planning. And if that is going to happen, again, what we call the drop and swap, are you going to have a conflict in representing one of us if we're not, for example, fully dissolving, and I say, well, I want to keep the partnership and we're just going to redeem out Diana? Lots of cross currents around all of that. So that's a just brief point. So again, communication. This is Rule 1, New York 1.4. I'll reference some model rules. I did kind of go in lockstep with one another, Model Rule 1.4. But again, there are critical deadlines. It is imperative that we understand who's monitoring things, who's working with the client on this. Obviously, you have to know how your client wants to be communicated with. I would expect it's probably going to be basically virtual, via email. All of our documents are being circulated via, PDF or DocuSign, but there may be occasion that they need to be called on the phone and a little hand holding. And, there are occasions where I'm more than happy to do that with regard to sort of substantive 1031 aspects. But, there could be other things that really are better suited for you to address. And you should understand that despite the fact that I'm a lawyer, again, I am not creating an attorney-client privilege with the client. And there could be some strategy that's going to be involved with their exchange, which I probably don't want to know about. So we will touch a little bit on that as well. So New York Rule 1.2c. And did I pass a slide there earlier? I think I might have. Okay. This is the one I wanted to mention here. So understand that in a malpractice claim, that the plaintiff doesn't need to specifically claim the malpractice fell within the scope. It's going to be the defendant, aka the lawyer that represented the client, to provide documentary evidence that concludes that the scope of the engagement didn't include the matters alleged in the malpractice. So, look, a lawyer can limit the scope of representation. And, this again comes back to the fact that if you are simply planning to negotiate the contract and handle the closing and not monitor dates going forward, that's okay. But that should be something that has been negotiated or understood going into it. Now, it would be expected, of course, and this, I guess I should kind of inject a few thoughts around this. If a client approaches you to sell real estate, if I'm in your shoes, the first thing I'm asking is, what is this real estate? Is this their primary residence or is it an investment property? And start some dialogue around determining if this has been held for investment. Now, it could be their primary residence. Maybe it's a two-family, though. And so maybe there's an ability to get the Section 121 exclusion on, let's assume they're equally sized units, but 50% of it is their primary, and then do an exchange on the other 50%, which has been rented out, the last 5-10 years. You're never going to know these things if you don't have some dialogue around it. It's unfortunate. I occasionally am dealing with somebody that, will at least once a month, I'll get a call from somebody to do an exchange. And having done this quite a long time, going on 20 years here, what I do is first ask, when's your closing? Because I once early in my career got excited. I'm talking to a new client, walk them through the exchange process. And I said, so when's your closing? And they said, it was yesterday. And I said, well, we just wasted a lot of each other's time. So had to, change around the vetting questions there. I have to structure an exchange before that sale occurs. And the only way you or I are going to know that needs to be done is if you are having that dialogue with the client in advance of that closing. And quite honestly, you are going to protect yourself if you have an email from them that you've raised the concept of a 1031 and they're not interested. And that's fine. Again, maybe they just inherited it. Maybe they don't have a gain. Or maybe it's been their primary residence. Whatever it is. Maybe they have carry forward losses and don't need to do the exchange. But if I'm in your shoes, I want that in my file that I raise the concept that this is an investment property. Look, if it's a multifamily 5-unit thing, I doubt they're living in all 5 units. So it is, or if it's a shopping center, right? It's either an investment property or maybe it's used in their trade or business. But that's where you get to, do you have a gain? And that's where you say, what's your adjusted basis? Let's find out from your CPA. Have you held this for investment? Maybe they're just a flipper. They bought it with the intent to resell it, which would likely not qualify. So, these are things you're not going to know the answer unless you ask the questions, right? So, you can limit that scope. If they are just going to pay you to negotiate that contract and handle the closing, and that's going to be the end of your relationship, that's fine. But limit that scope of representation, right? So you've got a couple of different, a broadly defined one, that you are engaged to represent them in the disposition of the property located at 123 Main Street. There was a case where a firm was engaged to assist a tenant in, communicating and evaluating their lease. And there was a term in there that they needed to renew, and the law firm didn't raise it to them. And, in the end, the plaintiff in the negotiation with the landlord should have included that. It would seem appropriate that it shouldn't have just been, well, you asked us just to look at one other thing. It's a murky area that you don't want to be in. So, be very specific about your engagement. It would certainly appear that if you say, for example, that you're engaged to represent them in the negotiation, drafting the docs, and handling the closing, that looks a whole lot more like that's the end of the relationship. But again, in the broadly defined one, I don't know, why aren't you still maybe included? Are you expected to read all the exchange documents? And we're going to talk about that because there was a very recent case that lacked some integral clauses, one particular, the G6 restrictions, and it blew the taxpayer's exchange. So we're going to talk about that, but that should be contemplated in your fee. I mean, there's going to be a whole suite of documents that I need to prepare, send to you and to the taxpayer. You're going to spend time reviewing them, so you ought to know whether that's been contemplated in your agreement. And then, an express exclusion of services that your scope doesn't include advice or services regarding accounting or tax. And so that, again, can be specific to 1031 exchanges. So if a taxpayer comes to you, and again, I would encourage you to make 1031 exchange what we call cooperation clause language. Just make it boilerplate in your agreement. I mean, this could be your best friend and they're selling their primary residence or their condo on the beach in Florida that they spend 6 months a year at. Okay, well, that's not going to qualify. But what if the buyer's doing an exchange? Like, why not just have it in there, make it reciprocal, and then that ends the conversation around that. But, if they do say to you that they want to do an exchange and to put some language in there, I mean, are you obligated to do that and to make sure that the proceeds go into the qualified intermediary's exchange account? I mean, I would argue you certainly would be. Okay. So again, you want to have that cooperation clause language in there. It's going to be imperative that before that closing occurs, that I generate the exchange documents. I'm going to need to get a copy of the contract, the title report, trust or corporate documents if applicable. We're going to open up an exchange account here at the bank. And when that closing occurs, you are going to be expected to wire the funds into that exchange account. And we set it up through a trust, which is another level of security, and we'll talk about that. So it would be expected that you are going to send that money, that you understand that if you send that money to your client directly, you have blown their exchange. Now, they may say to you, listen, I just want to take $50,000 at the time of my closing. I'm not rolling it all in. I understand I'm going to have a small tax issue on that. Great, that's fine. And that can be done, by the way. It is not an all or nothing proposition. I would need to know how much money they plan to take before that closing occurs. And you would need to know how much money they plan to take because you got to cut them a check or wire them the money separately that they understand is not going to be part of the 1031. It's important to note seller financing has become a lot more prevalent. If we were sitting in a room together, I'd ask for a show of hands. But I've seen a tremendous uptick in seller financing deals where the buyer is not coming up with all the money and the seller is going to finance some of the transaction. You need to make sure your client understands that unless they're in the financial position to substitute that seller financing amount into the exchange account before they acquire their replacement property, they're going to have a tax issue on it. And the structure of doing the exchange is a little different in that I have to be the payee of that note. Okay. And then when they fund the account with the amount equal to, let's say, that note, I'll endorse it back over to them. So, these are some important aspects of structuring that need to be addressed. Again, looking through transactions, asking early, if you're negotiating this seller financing piece, light bulb go off. Hey, I better talk to the client around this because there could be some cross currents that they're not prepared or in a financial position to even make happen. Are you obligated to do due diligence on the qualified intermediary? Well, I think it's fair to say that if you are making that recommendation, that you would be expected to have a little familiarity around them. And, of course, the things that I would expect you're going to look to is first and foremost, the security of the funds, understanding, and Richard said this earlier, that this is an unregulated industry. And we have seen Ponzi schemes. We've seen bankruptcies. So understanding if you are working with a regulated company, such as Chicago Deferred is part of Wintrust Financial Corporation, $56 billion bank. We're subject to government oversight, right? There are some methods to get you to a place without a regulated company if you're using a trust structure, which we also happen to use. Or if there's a qualified escrow agreement that will create a three-party agreement and put the bank on the hook should something go awry. But understand that fidelity bonds don't necessarily, provide security that you might think it does, because typically a security bond is going to provide security if there is a fraud perpetrated by an employee and they wire money, somewhere. But if it's the owner perpetrating the fraud, which it 99% of the time appears to be, that's probably not covered under that fidelity bond. So are you reviewing that fidelity bond and making sure you understand everything? Of course, providing a few names is probably good practice. I always encourage that. Unless you're giving my name, then just give my name. And, if we were in person, hopefully I'd hear a chuckle or two. So, again, building those best practices around that. So again, are you obligated to track these critical deadlines? Well, you're in the notice section of this contract of sale, and I'm going to be, of course, sending you all the documents for the exchange. It's expected you're reviewing those. What are we doing? After the closing occurs, I'm going to be sending the client and you these critical deadlines, and I don't know. I'm not getting your scope of engagement to know. Now, I've had attorneys say, I'm done. Our scope's over, and just work directly with the client, and that's great. That's fine. Perhaps the client's selling here in New York and they're buying in Florida, and you're not involved in their purchase. Well, doesn't mean you're not necessarily involved in tracking the critical deadlines, assisting with the identification. So, I would have no way to know that. So, one of the big issues is around qualifying property. And the spirit of a 1031 exchange is that the property, upon acquisition and sort of expected the current holding of it, is that the intent isn't to liquidate that investment or use it for personal pursuits, right? So that's what we get from the Bolker case. That's sort of the spirit of any 1031, is the intent is not to use it personally or to liquidate it, meaning to flip it, right? So one of the important things, again, for you to know is, what is the CPA? How are they treating this client of yours? I mean, maybe your client's a dealer, and, there's a case where a taxpayer owned property for 11 years and their exchange failed. Now, why did it fail? Because they were a developer and they were developing land. It was held on their books and records as works in progress, not held for investment. So again, these are things you will know if you are having a conversation with the CPA. So in this particular case, real quick, properties acquired in August, they sold in August, they bought in November. Here we are just a few months later, and they're in contract to sell. And they call you and they say, I want to do another exchange. So again, first and foremost, is the CPA on board with this? But the real question is, did they hold it for investment? Was their intent to liquidate it? Now, it very well may have been they bought the property in November, they put a tenant in place, and 2 months later, the tenant says, I know you just bought this. I just hit the lottery. I'll pay you 3x what you just paid. That appears to be a good fact pattern to me. Okay. Now, there may be situations where the client has, a whole number of investment properties within a building. And so, question may be, and this is a little bit of a trick one here, client acquires a condo for personal use, giving it away there, personal use. Okay. Their intent wasn't to hold it as an investment. And they bought it for $1.5 million, and now they got an offer to sell it for $3 million, right? So, boy, I don't want to pay gain on that. So how do you approach this with your client, right? I mean, it's a little hard to know. How are you evidencing that you were acquiring this for your personal use? I mean, there may be some facts and circumstances around that. Clearly, had they bought it and immediately made efforts to rent it, then we know that it appears they held it and planned to treat it as an investment property. But what are you going to do when they say to you, well, I'm going to sell it and I don't want to pay tax? Again, you better have CPA buy-in around this. And, do you get creative? Do you maybe have the buyer lease the property from the tenant and then have some option to buy it at a later point? Well, it really should have some independent economic substance to whether they are required to buy that or not. And so now maybe they aren't going to buy it. So, there's no real sort of amazing guidance that I can give you around that, but these are some of the things that you may be confronted with. May have a situation where somebody owns, this is now the 10th condo that they're selling in a building. And maybe they still own a whole lot more. Well, are these held for investment? Are these held on the books and records for investment? Or are they works in progress? Is this a developer? Did they buy an apartment building to convert to condos and that becomes inventory to them? There are some facts and circumstances that the courts have come up with around the purpose for which it was originally acquired, the extent of the improvements that were made to that, the frequency and number and the continuity of the sales. Well, this, what period of time is this the 10th? Is this over 5 years or is this over 1 year? Doesn't start to look too great, right? So those are some things to think about around that. Now, I mentioned a little bit earlier around partnerships and understanding that, the taxpayer requirement around a 1031 is that a taxpayer that sells investment property has to be the taxpayer that buys the replacement property. So in that situation, if a brother and sister approach you to sell a property that's owned in their family LLC, it's taxed as a partnership, well, there's no question that as long as they plan to stay together, brother and sister can have the partnership sell the property, and brother and sister can buy a replacement property through that partnership, right? Whether it's that exact same name or through a newly formed single member LLC for which the partnership's the sole member. People often confuse and say to me, it's the partnership selling. Doesn't that same XY's family LLC have to go on title to the new property? It's not about entity name. It's about taxpayer. And as a single member LLC disregarded for tax purposes, that is the same taxpayer in my example, meaning family LLC can buy two properties through 123 Main Street LLC and 200 Oak Street LLC, as long as those LLCs are single member, with family LLC being the sole member. That is the same taxpayer requirement. But let's say brother and sister want to go their separate ways. So again, if partnership enters into contract to sell the property, brother doesn't get 50%, do your own 1031, sister, the other 50, do her own. Doesn't work like that, right? So you have to do some advanced planning, ideally. Perhaps in a prior tax year, again, when we talk about audit risk, which again should not be indicative of how you give advice, But the Form 1065 has a specific question whether during the tax year tenant in common interests were distributed. So these are things you have to be cognizant of. What are you going to do now? Well, most likely you're probably doing a drop and swap. You better get that CPA's blessing. You will likely dissolve that partnership into a tenant in common arrangement. But, if you were engaged by the partnership, well, don't you maybe have a different obligation to the brother or the sister, or, if one of them approached you? And there can potentially be issues if, for example, and, this is a little different with just two members where, but I may say, look, my sister wants to do an exchange, and I come to you and I say, look, I engaged you and I'm going to keep the LLC. You're going to redeem out my sister and I'm going to keep the partnership that's been on title for the last 20 years. Looks a whole lot better. I don't want to just, upset the apple cart here. Well, sister's exchange might not be exactly on the same footing as mine. Okay. By the way, I'll do that in 2 minutes. So things to think about around that. And so this leads us to conflicts of interest. And I would expect, have a conflict of interest, Model Rule 1.7 and New York Rule 1.7, that, you should not represent a client if there is differing interests. And that certainly could be the perception around doing a drop and swap where they may not be on equal footing. Now, if you fully dissolve it, then you put the two of them on equal footing. But if I, as I said, say, no, listen, I'm going to keep the partnership and you just redeem her out, a little bit of different footing, I believe. Okay. So now what do you do in those situations? Of course, if you reasonably believe that you will be able to provide competent and diligent representation to each, great. Big thing, informed consent, right? In writing by both parties. There's oftentimes, and so in the spirit of this, again, regarding doing a drop and swap, there are questions around sometimes the replacement side. So again, looking through a transaction and understanding that partnership interests are not exchangeable. Well, if your client sells a property, let's say individually, and they're telling you about how they're going to set up a new LLC with their friend to buy replacement property, well, that's going to be a problem because partnership interests are not exchangeable with the exception of two limited situations under Revenue Ruling 99.5 or Revenue Ruling 99.6. Again, that's the advance outside the scope of what we're going to talk about here. But understand that your client can't just set up a new LLC with their friend. That is a presumably partnership, different taxpayer, right? So these are things that you have to be aware of. Can they buy the property and then maybe contribute it? It appears that is a more acceptable path. Now, again, probably shouldn't be a foregone conclusion that it's, going to roll into this new partnership, but that certainly is a strategy that many tax advisors have a good comfort level around. So that's a little bit about, and people 2 years, 10 times this week so far, people, don't I have to hold the property for 2 years? No, there is no bright line rule that talks about 2 years. The reason that people talk about 2 years is because, as I mentioned earlier, related party transactions, that uses a 2-year holding period. That has an exception for a 2-year hold. And for second homes and vacation homes, Revenue Procedure 2008-16 looks to essentially a 2-year holding period before selling a second or vacation, and similarly on the acquisition side. So, again, it is not a bright line rule. So be very careful and understand the ramifications that the deal maybe is not going to happen now, if they think that they have a 2-year hold. So again, this is a little bit more around the concept of, are you going to advise them to wait 2 years before contributing? Is that going to blow maybe a development deal if they're buying land and contributing it? Tenant in common arrangements are perfectly acceptable, right? So if in my situation, client wanted to buy with a friend, well, they can buy as tenants in common, right? So understand that's going to have ramifications as it relates to their identification. They better not just list 123 Main Street. They better list a 50% tenant in common interest in 123 Main Street, or they could list a dollar amount as an acceptable way to identify, given that it's both the equity and debt component. So those are some things to think about. I think it's sort of fair to state that, you don't want to be getting involved. Unfortunately, unfortunately, there are many taxpayers as early as last week on a $60 million transaction asked me whether I was going to take a late identification from them. To which I said, well, if you're asking me if I'm going to assist in tax fraud, that's not going to happen. So, by that same token, like me, you spent 3 years in law school. I don't know, maybe you spent less, maybe you spent more. But bottom line is, I think it was a lot of hard work, and I don't think you're looking to jeopardize that. So, that's sort of a non-starter. This Dobrich case, taxpayer backdated their ID. Their exchange, of course, was disallowed. And they had both civil and criminal fraud penalties. By the way, I'm going to inject right now that the code for today is CDEC 1031 exchange. So again, CDEC 1031 exchange is the code for today. So we're going to carry on. Nobody drop off. I'm going to find you. So very important. You have to specifically list the date that you identify property on the 8824, which is the informational return for a 1031. So we are all exchanging documents via email. Don't tell me that your client went to the post office and licked a stamp and put their ID in the mail. It didn't happen. Okay. So, it is imperative that if you are aware of a qualified intermediary that is what is referred to in the industry as an accommodative accommodator. Again, it's an unregulated industry, and unfortunately, there are bad players. And the point is, they're assisting their client in committing tax fraud, and they're doing them a disservice because there is no way that that client is going to prove to the IRS upon an audit that they identified on that date. There is no IRS agent that is going to believe that all of our documents have been circulated via PDF and email, and that you magically went to the post office. It just didn't happen. So this again comes back to, if you are aware that this is happening with a QI, I would strongly encourage you to work with a different QI and encourage your client to not be working. Because, by the way, if your client's doing everything correctly, they're going to get thrown in with the bathwater there when that QI goes down and gets audited. And every exchange that they did, by not adhering to the G6 restrictions and accepting late IDs, they're not serving as a qualified intermediary. Now, we talk a lot about critical deadlines, the 45 and the 180. I do want to point out that from time to time, there are federally declared disasters which may extend those periods of time for affected taxpayers. Right now, of course, Los Angeles had the wildfires in January. Those affected taxpayers, and it becomes a little nuanced, so don't take this as for everybody, but for the most part, people that's primary residence or place of business is based in Los Angeles, they have until October to identify and or close on their replacement property. They may otherwise have difficulty meeting their deadline if, for example, their CPA is in Los Angeles and they couldn't get a hold of them for a week because of the fires. So that may, even though your client may be here in New York, but their CPA is in Los Angeles, may give rise to an extension. That is likely something, again, you ought to get that CPA's blessing as to that. Now, this has always been part of my presentation around ignoring the G6 restrictions. And, it's great for me, but not so great for the taxpayer that worked with a bad QI. I'm going to share in a moment a 2025 California case so that, it's just an interesting point here. Understand what the G6 restrictions are. In the same way that I just talked about late identification, Well, you have to be aware that there are G6 restrictions that must be in the exchange agreement, okay, in any sort of escrow, qualified trust agreement. The point is that there are certain, this is not a bank account for the taxpayer to call me and say, hey, you received $1 million from my exchange and I have an Amex bill that I want you to pay for me. That's not going to happen. There's a limited universe for which I can release money, and there's a limited time schedule for which I can release money. And taxpayers that think that the QI, again, is doing them a favor when they say to them, look, if you identify and, if you change your mind on day 60, we all understand you're going to pay tax and I'll just send you your money back. The problem is they are not adhering to the G6 restrictions. When a taxpayer starts their exchange and I begin to hold money for them, unless they don't identify to me, I can't release money until the 46th day. So if week one, and this happened one time, and I said, well, you couldn't figure this out before you closed. If week one, they say to me, I'm not doing an exchange, send me my money back, I have to say to them, we have to wait until day 46, given that you don't identify. Now, once we're past day 45, they did identify to me. Day 50, day 60, they complete their due diligence. They don't like the property anymore. Or the seller, they were never in contract. Seller now has taken it off the market or sold it to somebody else. Now I can't release the money until the 181st day. And what happens is there are some QIs, they'll say, oh yeah, I understand you're paying the taxes. I'll just send you the money back. Well, what happened to this contract that we entered into with the G6 restrictions? Can't do that, okay? What's interesting is that there was a case, and this goes to not just, mailing it in, so to speak. When you get exchange documents, you better review them. There was a case, it took place in 2014, and again, just this year, we got this case note around, it's called In the Matter of the KM Trust. It was a 2025 OTA California case where a taxpayer did an exchange. They work with a QI. I've been in this business for going on 20 years, and I'm a co-chair of our industry conference. I tend to know pretty much everybody, never heard of them. Bottom line is, this QI did not include the G6 restrictions in their documents, not in their exchange agreement, not in their escrow agreement. And so what happened? This was a $17 million exchange. California likes to audit everything, right? They got to get their tax dollars. Well, they said you didn't have G6 restrictions in your language. That QI was not a qualified intermediary. You had possession, you had constructive receipt of those funds. You could have said to them anytime, send me the money. And the taxpayer argued, no, it was a Scrivener's error. They said, no, it wasn't. Failure to include G6 restrictions is not some mere clerical error. This case was settled within a month. Okay, I think that speaks to a large law firm representing the taxpayer in the sale, and there were professional negligence claims against, everybody involved. So that was settled within a month, as I understand it. So I think that speaks to the significance and importance of reviewing that. They really didn't have a leg to stand on. So again, this qualified intermediary, again, disregarded third party, somebody that has not served as the taxpayer's agent, meaning you, their CPA, an employee, the real estate agent. So again, unfortunately, I have clients sometimes say to me, oh, my CPA did it for me last time. I say, wow, it's sometimes people just don't know what they don't know. I know Richard in the beginning raised the Land America failure that was back in the financial attorneys. Is there some sort of trust agreement, which is the highest level, where now the asset is not one of the QI, nor is it an asset of the bank where it's deposited? That's the very nature by operation of law of a trust agreement. A qualified escrow account, putting the bank on the hook. So you have a three-party agreement between the taxpayer, the QI, and the bank, so that money can't be released without everybody's sign off. So that limits, a QI from just stealing the money and sending it somewhere. Again, trust structure, you have a trustee that's overseeing everything, and that asset is not one of the banks. So if you're concerned about a bank failure, none of those other things are, a qualified escrow is not protecting you. That's where FDIC insurance comes into play, which of course is quite limited. So that's a little bit on that. Again, I've heard of accountants that are doing it for their own client. I've heard about attorneys that are doing it for their own. That's a no-no. That's just simply not understanding how this works. Okay. So with that, I think, of course, if you're benefiting from referring to a QI, or, those are things that obviously is sort of a different nature of a conflict of interest, where you are, your own financial personal interests are in advance of a client. So with that, I hope I've given you some things to think about around 1031 exchanges. I'm always happy to be a resource. This is my number. You can reach me directly here anytime. Should you have a client that has an exchange question, or should you, or of course, the need for a qualified intermediary, I hope that you will keep me in mind. And with that, I thank you for your time. And again, big thanks to Judicial Title and to Diana and Richard for having me. And I hope we'll see you at a future 1031 exchange presentation. And feel free to contact me and connect with me, as I do provide updates on LinkedIn and otherwise. Thanks again.
Hey, Eric, I just have one outstanding question that you didn't get, that I dismissed them as you.
Yeah, I don't even see them. Yeah, go ahead.
Can I ask the one question?
Oh, please.
It says, if the seller of the acquisition property dies and they cannot complete the closing within 180 days, is there any extension of time to close?
No, that is not a 1031 exchange reason. That it's only a federally declared disaster. So that is absolutely a concern. If you can't take title, that's where you want to utilize the 3-property rule or the 200% rule, and maybe have a backup plan. You do have the ability to identify multiple properties in the event that something like that occurred. But yeah, there's, unfortunately, that would be a big problem.
All right. Thank you so much. We appreciate it, Eric. Great presentation. Thank you again. It's always a pleasure to work with you. And thanks everyone for coming, and we will see you next time.
Thank you, everybody.
Thank you.
Bye-bye.